Good day, all. So, just to confirm as we get started, if someone can hear me and see me, could they drop yes in the chat feature? All right. Well, thank you all for joining. Thank you for being a part of this. Was just confirming the tech side to make sure that you could hear me or see me. So, my name is Letitia Lister Burgess, and I am the executive director at EAP Bermuda. And I am delighted to be talking to you today about understanding the laws that impact mental health here in Bermuda. And so, I always say what you don't know, you don't utilize properly. And so a lot of the times at EAP, people come to me with very common questions. And so I wanted to be able to answer those questions today. But in order to do that properly, I needed to give you some history. And so I needed to be able to expand on what you know and give you more knowledge to get us to a different place. So there are three main pieces of legislation in Bermuda that impact mental health. There is the Bermuda Mental Health Act of 1968, the Human Rights Act of 1981, and my personal favorite, PIPA, that we've all talked about so much in the last couple of years, which is the Personal Information Protection Act, which was originally in 2016, but actually now is finally in full effect in Bermuda. And so it's taken a minute um, to finally be in full effect, but we're excited to see it come. So let's take a minute and talk about. Oh, I'm sorry. There is definitely something happening. Okay. So I want to take a minute and talk about some common questions that I get. And the biggest one I often get is, well, my family member has threatened to harm themselves. I don't know what to do. Can they be sectioned? And so, first off, the term is detained, and that would be under the Mental Health Act if need be. But in order to answer that kind of question, I need to give you way more data. So let's talk a bit about the Mental Health Act. So, as I said, that came about in 1968. And so that is a law that governs how people have access to services, access to treatments, their how they consent for things. And so what you'll see up here is actually from the Bermuda Hospitals Board and working with the Ministry of Health. They actually produced something called the Code of Conduct. And so it really laid out what are the rules of how people are supposed to be treated in Bermuda. And so it's really, really interesting to think about what is it that people are governed by. So the Mental Health of Act actually talks about the rights that people have, the requirements, and actually the restrictions that can be put on place in case someone has a mental health issue. The technical term is mental disorder, and actually that is a term that's in the Act, and it talks about mental illnesses. And so there isn't necessarily a live definition of that. It goes by the DSM or it can also go by the ICD. And so these are both diagnostic tools that are used worldwide or in the US primarily to talk about different mental health concerns. So the Mental Health Act, as I said, it has the requirements for whether someone actually needed to be detained for their own care. And it also wanted to lay out, well, what are the parameters of that? Who would be involved with that? And also wanted to make sure that there are protections so that people can't be detained for any reason at all. And so it was actually amended, as I said, in 2019. So I wanted to expand on some of that and put some more protections in place and requirements. And as I said, establish that code of practice that we now see. So the code of practice, as I said, was a joint venture between BHB, which is the hospital, or KMH, and between the Ministry of Health. And so it wanted to put in some things to give people more protections. And so what it did is it looked at how medical practitioners and other health practitioners can actually care for people. And so the code actually put in some 9 key principles that have to be upheld under the act. And so it really looked at things like community treatment orders. So a community treatment order is, for example, you know how there are houses here in Bermuda where someone, for example, maybe they had learning difficulties, are living in one of the what's known as the group care homes that are run by the Bermuda Hospitals Board. Someone, in order to live there, would have been under a community treatment order. So it isn't that someone can, wake up tomorrow and say, I'm struggling taking care of my sister, my brother, my aunt, my uncle, and I just want them to go there. No, there are actual parameters around that. So someone would have to be assessed. Someone would have to be seen by a doctor or a psychiatrist actually. And then certain things would have to be put in place as part of the Mental Health Act to put them on what's known as Section 22, which is a community treatment order. And so that was put in for people's protections because prior to 1968, in the past, in Bermuda, there weren't the same frameworks put in place for people's protections. And so there were incidents, and thankfully not any time in the near past, but there were instances in MWI's histories where people would be diagnosed and not know what their diagnosis was, were giving treatments and didn't even consent to it, or situations where people were taken for care and then never followed up with by their families and friends. And so it was really important that that was put in place to give people protections. Now, the other important thing about that is it really talked about the capacity to consent. And so, does someone have the capacity in this moment to consent for treatment? And so, we're going to talk some more about safety issues and when someone can't consent. But the law really wanted to make sure that that was taken care of. And so these are the most common sections of the Mental Health Act that I want to talk some more about to make sure that you understand it well. So, Section 13, which I'm going to expand in a second, is when there's an emergency admission for assessment. And it normally is only to 72 hours, which is 3 days. And that's when someone is normally at danger of self to harm or others. So, this is the part of the act that speaks to that. Now, if someone is, for example, suicidal, and they are concerned about their behavior and they recognize that they're suicidal, it doesn't mean that this has to be an involuntary assessment. So Section 13 is if it's involuntary. But if someone says, "Hey, I recognize I'm in a hard place, a deep place, a dark place. I'm worried about keeping myself safe." They can voluntarily admit themselves, and that's what's known as a Section 14. And so I wanted to make that distinction because it isn't always that someone has to go against their own. Sorry, it isn't that someone has to go in because of an involuntary hold. People go in for their own protection as well. And so that's Section 14, because again, there has to be parameters around that care. And then that last piece is Section 9. And so under that, that is past the Section 13. So that would be if someone, or Section 14, that would be if someone is been seen, has been deemed to be either a worry of being harmed to themselves or for others, and then there's a need for further assessment or further treatment. And so this can go for another 20, it's up to 28 days. And so that's when someone can be seen and, really work out an ongoing treatment plan for them. And so these are the 3 sections that are commonly talked about when we talk about someone being seen for long-term care or looking for an assessment for suicide or self-harm. And so I often talk about Section 13 in a lot of detail because I want people to understand this. So this is the part where someone will call me on, say, a Friday afternoon and say, Miss Lisa Burgess, I'm really worried about my family member and my friend, going back to that original question. I'm worried that they're going to harm themselves. What is it that I'm supposed to do? Where do we take them? What's supposed to happen? How do I keep this person safe? This is the part of the act that really speaks to if an involuntary admission is needed. And basically, what it says is that the nearest relative, and I'll talk about that in a second, a mental welfare officer, so that's someone who would work at MWI, or a police officer can make sure that that person is safe and that something can be put in place to have them assessed to see if they are, a concern for themselves or for others. And so there is a situation I'm thinking of where in the past someone had threatened to kill themselves at home. Their family member was concerned. They couldn't get into the person's room. What do they do? Going back to the same section, they were able to call the police. And so the police now have the abilities through this act to now do what's known as a welfare check. So the police were able to come out to the home with a community mental welfare officer from MWI. They were able to do an assessment and actually escort that person to the hospital for further assessment because it was deemed that they could not keep themselves safe. And so when we talk about it, those are the three categories of intervention of people who can intervene. So it's not just anyone in the public, it's not even me as EAP, it's a mental welfare officer, and that specific term was put in place by the act and is very clear on who that is. It's the nearest relative and it's a police officer. And so when we talk about this, this was a very interesting form that I found. And I, even though I've been in the mental health profession for years, didn't even know there were these distinctions. And so the first category is a husband or a wife. But if you notice, it then breaks it down. And I love that it's not gender specific. So sons and daughters have equal weighting, but in certain categories, there is different weighting given to, for example, if someone is a half sibling or a what they call a whole blood sibling. The law does not extend those same protections to step children or step parents, which is an interesting distinction by the law, but does give those same protections if you're adopted. So, for example, if you are a formerly adopted child, then it's the same thing in this category. Now, it does make distinctions. If you notice, for the first category is if you are married, but there also is one for common law. So if I've been living with someone as my partner for a number of years, then they're now considered to have rights under the act. Now, if you go back up to that first category, what's interesting is even though they're husband and wife, if they are formally separated, then that right goes away and it goes down to the next category. Now, in all of these categories, the person has to be over the age of 18 in order to make these decisions. And at the very last category, it says that if you're living with someone, this could be a roommate. So, a long term roommate situation, if no one else in these categories are available to make that decision, then that category can be honored. Okay, so if you're sitting here thinking, where do I fall on this? Whether it's a brother, a sister, a grandparent, an aunt, an uncle, they're all made for provisions under the Act. So, before we switch over to the Human Rights Act, let me come back for a second. Before we switch over to that, I wanted to take a minute to run through, well, honestly, what if someone is suicidal as a family member? What do I do? So, I talked briefly about the law, and here's how it comes to place. So, say in that situation, the person was taken to the hospital. So, they can go to one of two places. They can go to KMH and be seen there, or they can go to MWI. If it's during the daytime, it's MWI, which is the Mid Atlantic Wellness Institute. If it's any time of day, they can go to KMH and be seen there. Now, there they would be seen by an on call psychiatrist who would then assess for them to find out if they are safe or can be safe. And so, in that category, there are actually very specific questions that would be asked. And so, what they want to look is, they want to consider: can you keep yourself safe? So, there's a health and safety component to it. So, are you at risk of suicide or of actively harming yourself? Will your mental health get worse if it's not treated now? How big is the risk to you? Can you manage this condition on your own? Do you have the capacity to consent or to refuse admission or to refuse treatment? Is there a benefit to admission that's actually likely to outweigh the effects of having to be formally detained under the Act? And are there any other methods of keeping that person safe or maintaining the risk? And so, for example, if they, find that someone is depressed but not actively suicidal, then they're not going to do it, detain someone. Or if they find actually someone is suicidal, but not actively suicidal now, does not have active intent, does not have a plan, does not have means. The family is prepared to now, step up, take care of them. They are going to see their therapist. If there are other plans that can be put in place through the family, the friends, the community, then there doesn't need to be the Section 13. But on the other hand, there's another category that they have to look at: protection of others. So, what is the risk to other people? How likely is it that that risk will occur? How much harm could actually happen? Now, are there those that can provide support to manage the risk? So, for example, if someone says, I am thinking about harming someone in my family, I do have intent, I do have a plan, I do have means to do it, but they're away this week. Well, in that case, there may be an intent, there may be a thought process, there may be a plan, but the person isn't even there. So in that kind of circumstance, then it still wouldn't be appropriate to section. Okay. And so it's really about that delicate balancing act of how do we keep someone safe? How do we also keep others safe? And so again, in order to section, it would have to be an application through a mental welfare officer, two doctors, one of which, as I said, would be the consultant psychiatrist, or a locum psychiatrist would have to come in and assess. And so they would both have to be in agreement that this person is either a danger to themselves or a danger to others. And then at that point, then the application would go forward and that person could be formally sectioned. Okay, so it is not just, I'm worried about this person, I'm concerned about this person, and now they're going to be taken away to MWI and they'll be sectioned. That's not how it works. So I wanted to take a moment to kind of explain the law a little better so that there can be some clarity. So that's the Mental Health Act and how it impacts people on a day to day basis. The biggest parts of it that I find come in through the clinical aspects. Let's take a minute and come over to the Human Rights Act. So that is a very different act, because where this comes into play is I get this kind of question where someone will say, I've struggled with depression for a couple of years. Do I have to tell my manager? And can they fire me if I'm off work for depression? And so this is a question that normally comes from the lens of employment. And so when we talk about that, we have to understand some more about the act before I can even answer that question. So the Human Rights Act actually was enacted in 1981, but it was amended in June of 2016 and finally gave protections on the basis of mental health. This was an important change for the law because actually, sadly, up until that point, people actually could be fired around their mental health. So, or actively discriminated against. There could be a situation where, for example, if someone shared, hey, I've struggled with depression, but I'm working on it. Someone could have, prior to 2016, a manager, someone in a position of authority could have said, that's not the kind of person I want, working here. And so I'm going to let them go because I don't feel like they'd be appropriate for this job. And while that feels amazing to hear in 2025, that section, that change in the law is only 9 years old. And so that was a very important change to put in place because what it did is it gave them a protected ground. And so there's a protection in place now for people to know that if they're having a mental health challenge, they cannot be actively discriminated against. Now, the second part of it, which comes into the workplace as well, is there was also a changing to the expectation of reasonable accommodation. And so they now put a duty on employers to now have to do something about it. What do we do? How do we support people? Before, people could say, well, that's not really my concern. I don't have to worry about that. No, not at all. There are some expectations. And now the law says there are some things that have to happen in the workplace as a result. And so let's talk about a few of them. Now, there are some basic parameters, however. The person still has to be able to fulfill the basic duties of their job. And so if someone is in a space where they are completely unable to do their job at all, then that's not what we're talking about. That's not what reasonable accommodation looks at. And then there's certain criteria. Are they in a safety sensitive position? How big is the organization? There are some changes that can be made. If I have 5,000 people versus if I only have 5 people, what disruption will this be to the team, to the organization, to the work? The financial implications of it. But there are some things that can be done. Now, this is meant to be collaborative, so it should be a conversation between the person impacted and the organization, and it's on a case to case basis. So, sometimes people have worried about, what if I set a precedent? If I do this for John, do I do this for everyone else? Well, reasonable accommodation isn't like that. It says, well, what is best for this person in light of what's happening? And how do we make sure that that person is best accommodated for to make sure that they have the most success in your work environment? And so it can be a myriad of things that you'll see on the screen. But the ones I really want to talk about is things like if someone is on psychotropic meds, depending on what meds they're on, sorry, psychotropic meds are meds, for example, for things like depression, anxiety, bipolar disorder. So, say someone is on a medication like that, which is really helpful for them. But in the first couple of weeks, often, especially the first 28 days, it's a titration process is happening. And what that means is it's the brain chemistry getting used to this new medication. And there are often, a myriad of side effects. Some people report feeling more sleepy. Some people report feeling a little more lethargic. And so someone may come to you as a member of your team and say, hey, I'm on these meds, and I find that I'm just finding it really difficult to get up and make 9 o'clock. And so maybe a decision might be made by the organization. Hey, I know this person normally works 9 to 5, but actually for the month of November, we're going to have them work 10 to 6. And so that might be an accommodation that might be made. Or it could be, can I have time off during the day to go see my therapist or see my counselor? Or it could be something like, hey, could I have this kind of task instead of this kind of task? And so these are all just suggestions, but the law is saying that the onus is now on organizations to say, I'm going to work with you. And versus in the past where people could say that's not my concern, I don't have to do anything about it. The law says, yes, actually you do. And so the protection is in place for the person. And so when we talk about rights under the Human Rights Act, this is an important change that people have. And so let's talk if you're on this call and you're like, "Hey, I'm a manager. I didn't even realize this. I didn't even know this part of the law. What should I be doing if someone is out of work and returning back to work after, maybe being off for depression or, they had a period of time where they were anxious and they, were out for a period of time and they're coming back. Like, what should I be doing under the law to put things in place?" And so these are just some suggestions again to give you success as this person returns. One, maybe have a phased return. If they've been out of work for a week, 2 weeks, 3 weeks, maybe having them jump back in on a Monday into a full week might be overwhelming, especially if someone has anxiety. Having them start on a Thursday or a Friday to gently ease back in, or maybe they work half days and then transition to whole days, but having a meeting with that person in advance to talk about expectations, to talk about things about, well, what is the office being told? Going back to that piece where the person said, do I have to tell my manager? They don't necessarily. This could be going to a doctor and getting a sick certificate. But if this person is shared, for example, hey, I struggle with anxiety or I struggle with depression, that's why I was off. Confidentiality is still king. And so the office should not be told why that person is out. That is one, not okay because confidentiality. But two, think of mental health the same way we think of physical health. I don't have the right to say to someone else, hey, so and so is out because they have cancer. That is their private and personal information. So why would it be okay for me to say that person is out because they have depression? And so we have to always be mindful that confidentiality is now protected. I'll get to that in a second with PIPA, but personal information is just that, it's personal. Now, as I said before, are there any accommodations that need to be made? And so, because it's case by case, it's important that you sit down with that person. What might be helpful to them? Going to the part at the bottom, hey, do they have a support person? Do they have someone here that they could confide in or talk to or have a safe space to kind of just, do they have a day where they just need to cry? Is there someone here, even if it's not me as a manager, is there someone here that they can do that with? And then that last piece, having check ins with people, making sure that one, the accommodations are working out well, two, making sure that the work is still happening in a way that needs to because it is still a workplace, but three, making sure that emotionally they are healthy in this environment. And so that's really a big piece for managers. So I want to switch over to this last question. Do I have the right to access my file from my therapist? Maybe I've been seeing a therapist, I'm working through some things, and I just want to know what's been written down about me. So that's a very interesting question because prior to PIPA, the answer to that got a little bit complicated. I know for many mental health providers, um, people just didn't share their files. The general consensus was this was private, it was the therapist's thoughts, and there was even a mindset that people might not want to know what their actual diagnosis was. Piper said none of that. Absolutely not. And so Piper actually is the Personal Information Protection Act, and it's really changed the landscape here in Bermuda around confidentiality, especially when it comes to mental health. And so, as we all know, it came into effect in 2016, but it only fully came into effect of January 2025. And so the main purpose of this is really to look at how personal information is kept, how it's shared, how it's safeguarded, how it's used. And so, really putting in place a protection mechanism for confidentiality in Bermuda. And I think that's really important because it gave people the right to know that their information was only going to be used in the way that it should actually be utilized. So that could be anything from, hey, I signed up for a webinar at EAP, I gave them my contact information. I then can't use that information to come and call you and say, hey, would you like to come for counseling? That's not why the purpose of why you gave me that information. And so any information collected can only be used for the purpose it was collected. And so that's just a small example, but that's now part of your rights. And so when we pull apart PIPA some more, we now have different access points to information. So clients have the right to request access to personal information that's being held about them. And so they also have the rights to know the purposes of why people, especially mental health providers, are holding that information and if it's being shared with anyone. So, for example, I'll use an EAP example. If someone was coming into EAP and, their manager called and said, hey, I just want to know if John Smith is coming, I absolutely cannot share that kind of information at all. Now, if someone as a client said to me, hey, I want my manager, Mr. Smith, to know that I'm coming, well, we now have to make sure that we protect confidentiality all the way around. So they would have to sign a release of information. They would have to specifically say, I want Mr. Smith to know. They would have to specifically choose, can I talk to Mr. Smith? Can Mr. Smith talk to me? Can we talk to each other? So I just let them know about attendance. This person now my client now has to sign off on it. And only with that written consent can I then talk to their manager. And so verbal consent is not enough. It is written. And so that's really important that privacy is being codified as being protected. And so what we're talking about here is the right to access. Someone can call, someone can write, someone can email and say, I would like to have access to my file. I would like to know what's being written inside my file. And so Section 17 of PIPA speaks to that and gives that protection. There are other protections in place. They also have the right to access their medical records. They have the right to have information redacted. They have the right to know how their information is being stored or even blocked. So, say for example, I sent out, I don't know, a newsletter to someone on behalf of EAP. They could say, you know what, I don't really want to receive that. I don't want that. And they can say, please take me off your news list. Don't contact me again. And that would be the end of it. And now I have to respect that and say, okay, nope, I won't send you this information again. And so the rights that you have under Piper are really important to understand. One, to know how to access your information, how to request your information, how to redact your information, and to know how your information is being utilized. And so as we get ready to wrap up, because I do want to leave some time for questions if people have, I wanted to talk about the agencies that protect and act as the safeguards for these laws. Because it's wonderful having laws, it's wonderful having rights, but who are the people who make sure that all of this is actually being upheld, especially when people may not fully understand their rights? And so when we talk about the Mental Health Act, there was, as we talked about, the code of practice put in place, but they also put in a mental health tribunal. And so that's really important because it was an independent body that someone can go to and appeal. Say, for example, going back to my original example of the person who was deemed to be of harm to themselves, they were actively suicidal, they were under Section 13 at MWI for a period of assessment. And that person said, you know what, I feel like I'm fine. That is a violation of my rights. I feel like I am okay. I do not want to be here. they actually can either themselves or have someone on their behalf go to the mental health tribunal, lodge a complaint, and say, "Hey, I would like this to be, looked at." And so at that point, then the mental health tribunal can get involved. Or if someone, for example, was on a Section 22 or a community treatment order, as I shared before, and said, "Hey, I think I would like to know something different about my care, or I'd like a different treatment, or I feel like people haven't handled me well." This is a mechanism to protect your rights. And so I've shared that information so that you know if this situation is impacting you or someone you know or someone you love. This is who you get in contact with. And so this is how you contact them. You can call them, you can email them. They take walk ins. And so this is the protection for the Mental Health Act. So there's also a protection put in place for the Human Rights Act. And so the Human Rights Commission is the body that would investigate these kind of complaints. Again, they take walk-ins, you can email them, they have investigation officers. And so they would sit down with you and hear what your concern is. If you're saying, "Hey, I feel like I was passed over for that promotion because I thought I was confidentially sharing with my manager that I have anxiety, but actually when I turned around, it came up on my PIP. And someone mentioned to me at the management level that, I'm not appropriate for a manager because I get anxious." That is definitely something then that you would go and talk to the Human Rights Commission about. That is a possible violation because they're actively discriminating on a protected ground. That protected ground is mental health. And so, the same way they can't discriminate against you for things like your gender or your religion, they also can't discriminate because of mental health. And so, the person you would speak to there, well, the person in charge there is Lisa Reed, but you would speak to one of the investigation officers and they would look at a formal investigation process. And so they try to look at mediation. And if it can't be solved through mediation, it might even go to one of their tribunals. And so it's important that people know that they always have recourse. Now, as we now know, we've talked about Piper to death. As many organizations try to figure out how do they now get to make sure that they're compliant. Are they storing information properly? Are they sharing information properly? Are they utilizing information properly? And if you at any point as an individual feel like my information has just not been safeguarded in the way that it's supposed to, or something was shared that should have been confidential, then again, there are mechanisms in place. And so PrivCom, which is the Office of the Privacy Commissioner, is where you would go to lodge a complaint or ask for an investigation. And so this is where you would go to get some answers on how your information is being stored. And so again, they take walk-ins. You can email them, you can call them. They do formalize investigations. And so they would be able to walk you through what are your rights and what could be happening and what needs to be done as a result. And so I wanted to share today a little bit of the law so that you understand a little better. So, again, the three most important pieces of legislation: the Mental Health Act, the Human Rights Act, the PIPA Act, to really help you understand what are your rights when it comes to mental health in Bermuda. And then I also wanted to make sure, one, you understood a little bit more about some intricacies of it. What are your protections? And then who are your safeguards? Who are the agencies to make sure that your rights are actually being upheld? And so I'm going to take a minute now to pause because I shared a lot of information and ask, are there any questions? Are there things that you wanted to know that I may not have answered quickly? Or there may have been things that you wanted to know that I may have gone too fast by. So if you have any questions, now would be the time. So I can't actually see, sadly, if you guys have questions. I'm having a little bit of technical difficulties. So I will answer a question that is often sent in to me, though, which is, now that I know my rights, what am I supposed to do about this? Like, it was interesting information to have, but what do I do now? Firstly, look at your own organization. Are they protecting information well? Do you now know what your mental safeguards should be? What is your mental health policies if you have any at work? Are there any protections around reasonable accommodations? As a management team, have we talked about this? As employees, do I understand what my rights are? Let's talk about it from a family standpoint. If something was happening with your loved one, do you understand now what next of kin looks like? Do you understand what the safeguards would look like? Do you understand who the people you can reach out to? MWI has a confidential number that you can call as a crisis at any point, that you can kind of get support if you're concerned about someone. As we know in Bermuda, suicide is a very serious thing. And I don't ever want a family member to worry about, what would happen. As I shared earlier, there can be a section 13 when it's involuntary, but there are only certain parameters around that. One, that someone is actively in the moment at danger of harm to themselves and others. But two, there can also be a section 14 where if someone knows that they are struggling right now or need support, that they would then be able to get the support that they need. And again, those have clear parameters. It's only 72 hours. And so there are not situations where people, for example, go for an assessment and they're kept forever. And so putting those kind of things in people's minds to help ease any fears. And so the other part of that is consent. If you're seeing someone, you have the right to know what is in your treatment plan. You have the right to know what is the care that you're being given. You have the right to deny that care, or refuse any sort of treatment. These are all your rights under the Mental Health Act. Again, going back to the Human Rights Act, you have the right to be free from discrimination. And so there may be a chance to look at your policy and say, hold on, we have things in place for medical leave. We don't have anything in place for mental health leave. Do we need to look at that as an organization? And then for the protection of your information, that's a really big thing. Do you want to be able to access your file? Know the parameters on it. So, on PrivCom's website, they actually have a really rich guide that lays out how do you access your information? How do you request that? And organizations have been given their own guidelines as well. So, for example, I'll speak to only EAP. If someone formally requests their file, we have our policy where within 30 days we have to respond back to you with that data. And so it's not the situation anymore where someone could say, well, I'll get to it when I get to it. There are legal parameters put around how long that request should be taken. Do they have to respond back to you? So, for example, if there's going to be a delay of any sort for any reason, the organization is responsible to write back to you and let you know the reason for the delay. And so you have protections that are in place now that are legally yours. And I want to invite you to use those well, to take advantage of that and really understand your rights in order to move forward in a new way. So, thank you so much for being a part of this today. And I hope that this was helpful. Lastly, I wanted to end with a quote, but I also wanted to take a moment to give people a direction after this. So, here we go. I can be reached at any point. My email is info@eap.bm. And if you are concerned about your mental health in Bermuda, your rights around mental health in Bermuda, something in this presentation triggered something for you, and you think, I just need some more information, or I have a question, or I'd like this to be expanded further on, please contact me. I'm very passionate about making sure that people understand their rights, that people understand their protections. And so we always want to make sure that you have what you need in order to get the support that you need. So whether it's from us at EAP Bermuda, or whether it's from, just myself in understanding the law and your protections. So whether it's at EAP or anywhere else, the rights that you have around your mental health should be upheld. And so please feel free to contact us either at EAP or myself, and let's make sure that you get the mental health support that you need. So if it's in the work environment, it's things like setting up good policies. It's things like making sure you're looking at reasonable accommodation. If it's in homes, with our families, it's making sure that we're talking about mental health in a compassionate and empathetic way so people have safe spaces to explore those kind of things. And just as a general community, it's things like this. It's being part of the larger conversation of making sure that people understand what mental health means in Bermuda and how do we keep people protected and safe. So, again, thank you so much for being a part of this today. And I hope that you will continue to research some of these things. All of the acts can be found online, the Mental Health Act and the addendum, the Human Rights Act and the addendum, and PIPA Act. All of them can be found online. And in fact, with the PIPA, as I said, the guide is there as well. And I encourage people, if you're an organization, they have a guide for you there. It's very long, but I encourage you to read it. If there you are an individual and you're just trying to figure out, well, what are my rights? It also is a bit of a long guide, but I encourage you to read that one as well. And so I always say the protections are in place, but a lot of times people don't understand the law to understand what their rights are. So I want to take a quick moment to explain the laws briefly, to explain your rights briefly, so that you'll do the work now of doing something with it past this moment. So please read the acts. Please make sure you understand them and understand what this now means for your family, for your workplace, for Bermuda as a whole. All right. Thank you and have a great day.